Hello, my name is Colin Kelly and I'm a solicitor working in general practice in County Kerry, and I hope this finds you well. I wanted to talk to you today about an issue that can arise in respect of conveyancing practice, and that is dealing with common areas in a housing estate. When we talk about common areas, we're talking about essentially the roadways that come into a housing estate, the lighting, the footpath, the green areas and any other part of an estate that is used in common with everybody else. An important part of common areas is the services that lie underneath the roadways, dealing with issues such as sewage, telephone, electricity and those types of services. Now, a lot of issues can arise in respect of common areas, and a lot of stress and anxiety can arise from purchasers in connection with these issues, and there need not necessarily be. If the ownership of a common areas is with the original developer, or if the ownership of the common areas has been transferred to a managing company, well then there's no particular problem then with dealing with a housing estate, and really the first issue is the question of ownership. Where problems can arise, however, is that if an ownership of the common areas is with a company developer, or if the ownership has been transferred to a management company, and in those circumstances the managing company has been struck off the register for failure to file returns or for other reasons, well then that is a particular problem. In that situation, it would represent a bar to the title and the purchase of a house. So it's very important that in examining a title to a housing estate, it's been clear that the ownership of the common areas is with a company that's still on the register. If it has been struck off the register, then a procedure will need to be entered into whereby it's restored to the register, which means bringing up the accounts up to date, filing fresh annual returns and making an application to court. It is an expensive and cumbersome procedure. With ownership out of the way, the other issues that can arise then in respect of common areas are issues such as whether or not there's a sinking fund, is there an active management committee, and what's the position of insurance. And the solicitor dealing with the purchase of the common areas should investigate these by issuing what is known as MUD's requisitions, that is Multi-Unit Development Act requisitions, where all of these issues will be fleshed out and the solicitor will obtain all of this information. Finally then, I think an issue should be looked at is the question of whether or not the housing estate is in charge. If the housing estate is in charge by the local authority, that is a significant advantage, because it means that the housing estate now are looking after the maintenance of the roadways of an estate, and that they will also take responsibility for liability matters. A local authority will not cut grass as part of a green area. However, if there is an underlying ownership problem in an estate, like that I've mentioned in this earlier, that is not particularly solved by the fact that the estate is taken in charge. So that issue will still have to be continued to be remedied. I hope you found this information of your use, and I hope that you have a great day. Thank you.